Reporting live from the campus of CSUS, I'm Delia Chacon with the Criminal Justice Department, bringing to you a very important case. United States Attorney Benjamin B. Wagner announced today that Gabriel Richard Viramontes, 48 of Elk Grove, was convicted today of 6 counts of bank fraud and 7 counts of mail fraud. The guilty verdict was returned by a federal court jury in Sacramento after a 7-day trial before United States District Judge Edward J. Garcia. According to testimony presented at trial, Viramontes and 3 co-defendants who had already pleaded guilty to related charges engaged in a mortgage fraud scheme in the Sacramento area that involved at least 19 homes with loans of more than $8 million.
At the beginning of the jury trial, 12 citizens are chosen to be jurors through a 3-step process. Firstly, it starts with a listing of all potential jurors within the court's jurisdiction, called the master list. Secondly, those who report for jury duty are known as the venire, or the jury pool. In this case, more than 30 people came to court, of which 12 were chosen at random, followed by 2 alternatives. Thirdly, we saw the voir dire, otherwise known as to tell the truth. This was where the jurors are individually questioned about whether they will be appropriate to sit in on this case. Judge Garcia asked them many questions to determine whether they had any bias or knowledge of the case that would compromise their value as jurors. Only one challenge for cause, made by the defense, was made due to one of the jurors knowing the defendant on a personal level. Later, the prosecution was told that the defense has 10 preemptory challenges, whereas they had 6. The defense used 6 of them on jurors with backgrounds in either law or law enforcement. The prosecution only used 1. Due to all of the peremptory challenges, it took the entire first day of the jury trial to finally get the final jury panel. Then, Assistant U.S. Attorney Michael Anderson, who represented the prosecution alongside Assistant U.S. Attorney Matthew Stegman, presented the case in chief. This is where the party with the burden of proof, in this case the U.S., presents their evidence. Michael Anderson laboriously explained the prosecution's long list of exhibits that included diagrams of the mortgage fraud scheme, copies of transaction receipts from the Internal Revenue Services, and witness testimonies of Viramontes, victims, colleagues, cronies, and even his own brother. The defense attorney, Michael Bigelow, gave no opening statement. The prosecution dominated the rest of the trial, albeit after one shaky witness. Michael Anderson and Matthew Stegman became a relentless torrent of applicable law, government documents, and witness testimonies, especially the emotionally charged account of Viramontes' own brother, who was obviously taken for a ride. The defense attorney, Michael Bigelow, didn't really do a whole lot, except conduct some cross-examinations of the witnesses and make seemingly superfluous objections. In fact, Judge Garcia sometimes had to stop a moment and ask Bigelow if he had any objections to the statements said. When it was time for defense attorney Michael Bigelow to give his closing argument, he did his best to make the jury feel that any doubt they had would invalidate the government's case due to not showing proof to the standard of beyond a reasonable doubt. In the end, Assistant U.S. Attorney Michael Anderson gave his closing argument where he summarized the case and then reminded the jury that it is reasonable doubt, not any doubt, that is the standard for conviction. The jury retired to the jury room to return a verdict. After 2 weeks of this federal jury trial, the jury returned a unanimous verdict of guilty on all counts on March 31st, 2011. Through his mortgage fraud scheme, Viramontes robbed many of their money, credit, and well-being, and for that he has been caught and convicted for his crimes in front of a jury of his own peers. Mr. Viramontes is eligible for a maximum sentence of 30 years. The actual sentence, however, will be determined at the discretion of the court after consideration of any applicable statutory factors and the federal sentencing guidelines, which take into account a number of variables.